Hi, thank you for joining us today. We are going to be talking about I-9s and your responsibilities and rights as an employer. My name is Kate Dadetto. I'm a senior consultant with Red Clover. We are a strategic HR and change management firm. I'm joined by Brian today.
Thank you, Kate. Brian Klein here. My background is an employment attorney. I am at Weinstein Klein, one of the founders here. We are outside general counsel for primarily small business owners, and we help them deal with their legal needs. And as you can imagine, I-9s are a very hot button topic right now, and they fall squarely within what Kate and I do. And we thought you find people would benefit from a little quick primer about this.
Thanks, Brian. All right, so to get started, what is Form I-9? Form I-9 is proof of an individual's authorization to work in the United States. It must be fully completed no later than the third day after the employee's first day of employment. It actually can be completed before employment starts, but not before an offer of employment is extended and accepted. And it's required for all employees who have been hired after 1985. Looking at the form itself and how we complete it, when completing Section 1 of Form I-9, this must be completed by the employee. It needs to be completed on or before the first day of work. It must be signed and dated by the employee. If box 4 is checked, then you must also include the USCIS number, Form I-94 admission number, or the foreign passport number and country of issuance. Section 2 of Form I-9 is the employer review and verification. This is completed by the employer or an authorized representative of the employer. Brian, who can be an authorized representative?
Anyone, but be careful.
Anyone. But be careful, that's a good note. So anyone can be the authorized representative. This section must be completed on or before the employee's third day of work. You must add the employee's documents. So on this example, we have the List A document, a passport. The documents must be examined in person unless you are using E-Verify, which we will talk about in a little bit. And you must complete the certification at the bottom, including the signature.
So just a real quick before we move on, Kate and I were joking a little bit about who can be an authorized representative. And anyone is technically the right answer. Why is it a joke though? So the authorized rep rule, it's been around, I think, basically the entire time. And it makes a lot of sense. What it is saying is that the person, the employee, doesn't necessarily need to fill this out. The most important thing is that it is filled out accurately. This became a very interesting topic of conversation during COVID because, as you can imagine, the authorized rep rule plays a big part with remote workers. And so, when everyone had remote workers during COVID, authorized reps were popping up left and right. And technically, and anyone can do this, but the reason why Kate and I were joking about this, and it's not really funny, but we're employment law nerds, so it's funny to us. If you fill it out incorrectly, the employer's still on the hook. And so technically, yes, the employee's mother could fill this out as the authorized rep, but you want to make sure that someone knows what they're doing. That's the authorized rep because, again, if it's filled out incorrectly, the employer's on the hook. So technically, anyone can be an authorized rep, but if you're going to go down this authorized rep road, put a little, focus into who's going there and make sure that it's still filled out properly. Sorry for that little
Brian, who
detour.
would you recommend as authorized reps?
The employee's mother. No, but there's a bunch of banks do this. There's like agencies that do this, but anyone that is a trustworthy source. There are vendors. I know that a lot of these vendors and shops popped up during COVID that literally just do this. They act as the authorized representative. They're reputable, or so they say. And if you have to go down this road, I would probably opt for them as opposed to a relative of the employee, unless that
Um,
relative is a fractional HR representative or an employment attorney.
we often see companies that use notaries as their authorized representatives, which is completely acceptable, but it is important to note that the notary should not be affixing their seal to Form I-9.
Kate talked about E-Verify before, and before Kate goes into this a little bit, you may be asking yourself, well, what is E-Verify? So E-Verify is an online system. It's operated by Homeland Security in partnership with the Social Security Administration. It's designed to help employers verify officially whether a new hire is legally authorized to work in the U.S. How it works: you plug in the information, and then within seconds, you'll either get confirmation that the person is authorized to work in the US, or flags will be raised, and you probably should know there's a problem. E-Verify is voluntary for most places. However, if you are a federal contractor, you got to use E-Verify, and there are certain states, right, that actually require that you use E-Verify.
Yeah, so some examples of those states are Florida, Oklahoma, Arizona, Tennessee, and I believe Georgia as well. Each of the states have slightly different policies around this regarding employee population size. So I always recommend if you're located in one of those states that you make sure that you're looking at the regulation if you're not going to be using E-Verify.
It's also not a surprise, or it shouldn't be, that most of those states are in the South.
And the primary reason why employers use E-Verify is so that, or at least in my experience, is so that they can use what's called the alternative procedure. And this means that you don't have to inspect those I-9 documents in person. You can do it virtually over a video call, which is great when your workforce is remote. In
Okay, can
order
you?
to
I would go back, because actually I think we may have
Okay,
overlooked that before. When you so there's literally an in-person requirement, right?
there is.
So when you do that inspection that we were talking about when Kate was showing the form, the rule is that there has to be a physical in-person inspection, which again is one of the benefits of the authorized rep. They kind of act as the person who is physically inspecting if you have a remote worker. So that's literally what it's, physical inspection of the documents. That's annoying, as you can imagine. It's even more annoying if you have remote people. So there was a new rule that was changed. If you are an E-Verify enrollee and in good standing, you don't have to do the physical inspection.
And they call that the alternative procedure. So
No
if
air
you're
quotes this time.
using, I can do an
There you go. Thank
alternative
you.
procedure. If you're using the alternative procedure, what you have to do is create that case on E-Verify. Um, your list B item, if your employee chooses to use a list B and C item rather than a list A item, that list B item must contain a photo ID. You need to retain copies of the front and back of the I-9 documents, and you need to keep the E-Verify confirmation with Form I-9. Practically, when you're filling out Form I-9 using the alternative procedure, you're going to check that little checkbox stating that you have used the alternative procedure, and then in the additional information box, you should note the E-Verify case number. Now, how do we store Form I-9? Often, when I'm working with an organization, I find that they include their Form I-9s just in their employee files. This is not the best practice for storing Form I-9. The best practice is to keep Form I-9 in a dedicated file separate from your personnel file. Um, if you collect copies of I-9 documents, you must store them with Form I-9. If you use E-Verify, you are collecting copies of Form I-9 documents, and so you're storing them with Form I-9. but you also need to store the E-Verify confirmation. You must retain Form I-9s for 3 years after the date of hire or 1 year after the date that employment ends, whichever is later. What's important to note is if you are collecting copies of I-9 documents or using E-Verify, you must do so for all employees. You can change your practice as an employer, but you can't cherry pick and say, I'm going to use E-Verify on Brian, but not on Kate. You do the same for everyone.
Amazing how you can understand the reason for that, don't you, people?
What's the reason for that, Brian?
Well, let's just say that you probably think that some people are going to fail e-verify and others are not going to fail e-verify, and that kind of defeats the entire purpose.
So, how can we make sure that our I-9s are in order? Uh, I always recommend an internal employee file audit. This is one of the first things that I do when I'm working with a new organization. The method that I use to conduct this audit is I start by capturing a census that has employee names and date of hire. When I'm focusing on Form I-9, I also want to include former employees who meet that retention criteria. From there, I'm going to create a tracker, noting the documents that I have for each employee. So for an I-9 audit, I'm going to be looking for a Form I-9, depending on the company practice, potentially the copies of their I-9 documents, and maybe the E-Verify confirmation numbers. Um, Usually when I'm conducting one of these audits, I'm not only focusing on Form I-9, I'm making sure the entire employee data set is present. So I may also be looking at tax documents or legal agreements, and I include those in my checklist. And then I methodically review all places where employee files are kept. I always hope that there's going to be a dedicated I-9 file, but sometimes there isn't. So I'm looking through all of the employee files, the I-9 files, any HRIS system. Um, and as I'm doing that, I'm noting whether the documents have been fully and correctly completed, and where they're currently located. If I'm missing documents, I'm going to think about other locations where these documents might have landed over the years. Whether it's an e-signature platform, again, different HRIS systems, and sometimes even question if we have paper files that we haven't digitized. As I complete my audit, I'm going to correct naming conventions and file locations so that they're appropriately located for the future. And then my final step is to request corrections and revisions to the documents where necessary. And for Form I-9, there is a very specific way that we are going to make corrections. And I'm going to let Brian walk us through the correction steps for Form I-9.
So I'm going to just preface this with, because we're going to talk about audits, the bad audits in a second. Um, the most important rule is be honest. It's like that David Beckham, documentary. Be honest. Don't lie. If there was a mistake that was made, be honest. Especially if you're doing a self audit before the government comes in, guns blazing. Um, do not try to cover up or conceal any errors. If there was a mistake that was made, own up to it and fix it. We have here some specific ways to do things. So you may draw a line through the incorrect information, enter correct information. The most important thing I would say to remember when it comes to correcting errors is stay in your lane. So if there is an employee issue, only the employee can make the changes to Section 1. If there is an employer mistake, only the employer can make the corrections to Section 2. So stay in your lane and make sure that you are not trying to cover anything up, you're not trying to conceal anything, you're not trying to pull a fast one on the government, and you are making sure that you are doing things that are within your respective section. Now, I'm going to jump. So, the last part here, and this has been coming up a lot in recent conversations because, again, the reason why we're doing this presentation, I-9s are completely in the news. I-9 audits are, ICE audits are all over the place, and people are wondering what to do. And this is causing folks to do self audits. When they do these self audits, they reach out to me and Kate, and they say, "Oh darn, we don't have an I-9 for these people." Hopefully, it is a small number of people. A lot of times, it is a larger number of people. Whether there was a new HR individual that came into place, whatever the reason, we are seeing that a lot of companies do not have I-9s for all their people. Whether they can't find it, it was never done, whatever the reason, it is really important to focus on those folks and make sure that you have a valid I-9 for every single employee, current and former. Current's a little bit easier. So, again, be honest. Don't try to conceal something. Don't say that it's a replacement or anything else along those lines. You make a new I-9, whether, what I would recommend is you attach a memo to the new I-9 and you literally put in there all the information as to what happened. So the name of the employee, the date that you found out the error, the reason why you found out the error, what you're doing, the date that you did all the new stuff. Have the chief people officer, head of HR, whomever is doing the memo, sign at the end of that memo, attach the memo to the new I-9, and again, if rewatch this presentation to figure out how to do the I-9, but you got to get the documentation, make sure the employee fills out section 1, employer fills out section 2, and then you'll have that new updated I-9 with a memo that's attached. And if the government now comes in, you have a legitimate mea culpa, and they should go easier on you, but they will not, or you're going to hurt your chances that they will if you try to pull a fast one. So if you're correcting something and you find out about it, look here, draw a line, do all those things, but don't try to cover anything up. And if you find that you are missing I-9s, I highly recommend that you do a memo and you just create a new I-9 with ideally new information. If you happen to have the documentation that's necessary on file, I do believe you can use that, but just make sure that you're doing things as above board as possible. So if you have the documentation, it's current, but always, I think, better practices to get new documentation. If you have a former employee and you can't do this, same thing, make the memo and then just explain what's going on, explain the reason why you don't have the information, when you figure it out. And so again, you at least have something for that former employee. So if there's an audit, the government now knows that you were at least looking into this and you were trying to be in compliance.
While we're on the subject of current I-9s for your employees, common question that I get, probably one of my most frequently asked questions, is I have an employee who's going to be on an EAD, Employment Authorization Document. It's approved, but they don't have it yet. Can we get them started? And the answer is no. Individuals must have their employment authorization document physically with them in order for them to start work. And in fact, for individuals who are green card or employment authorization document holders, they must always carry their employment authorization document or green card, whichever one they have, with them. So it makes sense that they wouldn't be able to start work if they don't have that physically with them. What if you are starting an employee and that employee is not able to provide I-9 documentation? So they filled out section 1 that has their basic information in it, and the employer, the authorized representative, is looking to do the inspection of the documents, and the employee fails to present acceptable documentation. What happens next, Brian?
Or if they submit, you're on E-Verify and you get a flag that it's not proper.
Well, that one's a little easier because E-Verify is very structured and telling you what those next steps are.
Still, employers are humans and they have decisions on what they can do. and where we're going with this one. Because the answer is don't proceed with this hire, or proceed with caution. You should, and if you're not doing, you should reach out to either me or Kate. But you should have in all of your offer letters, employment agreements, or otherwise, some language that says your employment is contingent on you being authorized to work here and completing accurately an I-9 form. So it's a contingency. If you cannot do that, your employment was contingent on those rules. And so in that situation, you should not proceed with employing that individual unless or until you are able to fix and correct that error.
But if they've already started working and then you realize they are unable to provide their employment documents, do you still have to provide them with pay for that first day or two of work?
Kate, what do you think?
Of course, you always have to.
Yeah, we don't wanna snatch defeat from the jaws of victory with a wage and hour violation.
So, the big question is what does that official scary I-9 audit look like?
So it's still an audit, so it shouldn't be that scary. Although I do imagine that's gonna be scarier if you're not in compliance as opposed to if you are in compliance. But ultimately, it's an audit. It shouldn't be so terrifying. But this is gonna almost certainly come via ICE. It's possible that the Department of Labor could conduct this audit. It's possible the Department of Justice could conduct this audit, although probably not under this administration. Usually, what's going to happen is this is going to come by Immigration and Customs Enforcement, or ICE. So ICE will be the agency that is primarily responsible for conducting these audits. It is the most likely agency that's going to reach out to you in the event that there is an issue. Various triggers as to how someone will get selected for an audit. It is entirely possible that it's random. That's less likely. It's less common. Even I think under today's administration, it's more common, but it's still less. What happens is employee complaints. I mean, this is by far what I've seen is that there's an employee, either current or former employee, that files a complaint, and then that sets off the bells and the whistles within the agencies, and then they reach out to you to schedule an audit, which we're going to talk about in a few slides. Definitely, if you have been selected for an audit previously, your chances of getting a follow-up increases significantly because you're already on the radar, and they're going to want to make sure that you are complying with the rules, especially if you did not pass with flying colors during the original audit. Which again, because these usually come from employee complaints, passing with flying colors is not always a given.
Brian, what kind of employee complaint would likely trigger an I-9 audit?
It could be really anything. I think that this is a situation where you probably have an employer where there's some friction within the workplace. If there are allegations of discrimination, that could lead to complaints. We see that all the time. But that's usually what I'm seeing. What have you been seeing?
I think if you're an employer who does not consistently apply policies and procedures, more likely to be seen as a place that wouldn't have your paperwork in order. But the point that I would like to put forward is if you are an employer who is proactive about making sure that you have your T's crossed and your I's dotted, that your likelihood of receiving a complaint that would trigger an audit maybe is a little bit reduced.
It's definitely reduced. And just to kind of expand upon the employee complaints and why it's usually a former employee, the I-9 complaint is a little bit of an awkward one because unlike, let's say, an EEOC complaint or an SEC whistleblower, if you look at what the employee is complaining about, it's they didn't ask for my documentation. They're not following the rules with respect to whether or not people should be complying here, or whether people are authorized to work in the state. So it could be a disgruntled person who maybe feels like There are other people that are taking jobs away. It could be a situation where there's just a cultural issue. Um, but it's usually that type of scenario where you have some uh, disagreement, some issue that's going on from a cultural perspective that's going to trigger these, because unpacking what this actually looks like, what the complaint is going to be, it is this employer is not hiring people that are legally eligible to work in the country.
All right, so we know what is potentially triggering, what the agencies are. You mentioned that ICE is the most common agency to audit I-9s. So walk us through what that process looks like.
So when this happens, generally speaking, what's gonna occur is you're gonna get notice. So you're gonna get a notice of an inspection. This is gonna come from ICE, and it's at least 3 business days. That's gonna tell you you have to produce your I-9s. Do not ignore this. This is definitely legitimate. I highly recommend that you contact legal counsel immediately and make sure that your affairs are in order, so to speak. But that is going to be the start of the audit. It's going to be this NOI, and again, it has to be served at least 3 business days prior to the audit. So not a whole lot of time. Again, to Kate's earlier point, recognize this. An ounce of prevention is worth a pound of cure. Get your ducks in a row, because if you have this information already packaged, organized, etc., 3 business days is not a big issue. When the audit actually comes, they are, of course, going to look at your I-9s. That is a given. They're going to look at your I-9s for completeness. They're going to make sure that they were timely. So those deadlines that Kate was talking about earlier, about especially the 3-day rule, are followed. They want to see that the documentation is accurate. They can go outside of these rules, and they could ask for some additional piece of information. It's possible to oppose this. I would highly recommend that you speak with your legal counsel for strategic reasons as to whether you're going to want to comply or not. But it's not unheard of that they are going to request additional piece of information. And again, not hard to understand or realize why. If they're figuring out who has an I-9, they want to know who your people are. So something like a payroll record is going to be highly, highly important and relevant to seeing, I see 10 people here, 30 people here, and there's 3 I-9s. Something is not exactly adding up.
Okay, so we've gone through the audit, given them all everything they've asked for, or not, depending on what our legal counsel has advised us.
Very good. Thank you for the plug.
What's the outcome?
So there could be a couple of outcomes. Usually, what you're looking for is the old slap on the wrist, which is notice of a technical or procedural failure. So if you are in a situation where you have not done everything right, and again, because unless it's a random audit, you probably are not doing things correctly 100%. If they are minor, you're going to be given some time to correct these mistakes, and then you're going to work with the agency, and you are going to get back into compliance, and you're going to be good to go. Like I was saying before, you're on their radar. You should definitely make sure you're doing things even better going forward, because the chances of them coming back significantly increase. There could be a notice of an intent to fine. So this is going to be for some for more substantial violations. Like knowingly hiring unauthorized workers, missing I-9s, and things like that. And then there could also be a compliance agreement. So I believe this can be offered both in lieu of fines or in addition to fines. But generally speaking, if something is not right, you're going to also enter into an agreement to make sure that the employer is doing things properly going forward. Fines can range anywhere, as you can see, from a little bit to a lot more, and those are going to go up if you have been a repeat offender. So don't be a repeat offender. Don't engage in knowing violations. Again, this is the power of the self-audit. If you can I highly, highly recommend that everyone engage in periodic self-audits, especially now, of your I-9 documentation. If you find that there is something that is not done correctly and you correct it, you are going from a knowing violation most likely to something that is more of a mea culpa. You are trying to make changes before you even had a government agency telling you that you needed to change. And of course, it is possible for more egregious violations that you could receive criminal penalties or you could be removed from government contracts.
So what are our rights that employers need to remind themselves of and their takeaways?
This beautifully put together slide by Kate, you can see you have a lot of rights. Right to legal counsel is near and dear to my heart. Use it. Use your lawyers. We are good people. I promise and I swear. You do have a right to negotiate. You should negotiate and see what's going on, especially if you feel comfortable and confident that you have tried to do things properly. You've done the self audits. You have organized things like Kate was talking about before. Go in there and try to make sure that your voice is heard and that you're being put in a position that is not punitive. And if that fails, you always have a right to a hearing. What are some key takeaways, Kate?
That a government audit, is a serious matter with potentially significant consequences. It shouldn't be scary because ideally you are doing your internal audits on a regular basis to ensure that you have your ducks in a row. Immediate legal counsel is crucial upon receiving the notice. Uh, Cooperation with government agencies is generally advisable, but you always want to be looping in your legal counsel and seeking their guidance. And then, like I said before, proactive compliance, completing internal audits, I'd say at least on an annual basis,
At least, yeah.
is your best defense. Thank you for joining us today. If you have any questions about I-9, feel free to contact either of us. My name is Kate Dadetto. I'm a senior consultant with Red Clover.
And my name is Brian Klein. I'm an employment attorney at Weinstein Klein. I hope this was educational, informative. Like the slide says, please reach out to us with any questions. Definitely do those self audits. Get ahead of this. Be proactive. Happy to answer any and all questions that you may have. It's what we love to do.
And if anyone is watching this for SHRM recertification credit, the code is on the screen.